The NHS may do many things wonderfully well, but when it makes mistakes, it covers them up and it is not infallible in its diagnoses. And yet, in spite of all this evidence, the NHS has taken an unnamed patient to court over her and her family's attempt to resist palliative care and try nucleoside therapy in Canada, for which she needs to raise £1.5 million. The patient, known only as ST, owing to draconian reporting restrictions, suffers from a rare genetic disorder known as mitochondrial depletion syndrome. Her disorder now requires regular dialysis treatment, feeding through a gastronomy tube and a ventilator in order to breathe. The proposed move to palliative care by the NHS would see her die fairly quickly, which is why she and her family want a chance. They want to go and try the Canadian treatment as a last resort. But last month, a judge ruled that ST's fate is now the decision of the court, having been taken to court by the NHS, the family being taken to court to stop them having the treatment. And it was reported yesterday that the young lady's family is calling on the Health Secretary to give her a chance to save her life. But it should never have come to this. This young lady's suffering is immense. She is currently on course to be put on death row in a country that abolished the death penalty. The NHS is purely offering death. But who are these officials? Who are these bureaucrats in the NHS to tell this young lady that she has no right to pursue her last resort, to, in her own words, die trying to live? What's more, the court has imposed stringent reporting restrictions, maintaining the young lady's anonymity, which she does not want. It's been forced upon her. And this is turning anonymity on its head. The point of anonymity is to protect the patient, not to cover up for the hospital. The preservation of life is a foundational principle of our society, but it's being thwarted by the big state trampling on the rights of the individual. As always, I want to hear from you. Don't forget to let me know your thoughts. You know the email by now, mailmog@gbnews.com. I'm very pleased to be joined now by Andrea Williams of Christian Concern, which is backing the family, as well as the barrister Philip Taylor. Philip, I'm going to come to you first, if I may, to explain the law. Why have the judges granted anonymity, as far as one can tell, against the wishes of the family, seemingly to protect the hospital?
Well, I think the reason is based upon this document, which is actually the Court of Protection Practice 2023. The problem, as I see it, is a one for Parliament and for people such as yourself, because the mess that we now have with the relevant legislation, which is the Mental Capacity Act, and the fact that, in fact, this court is actually a relatively new court with powers similar to the ones that we have in the family courts, where everything is secret, and we try to protect, as you've indicated, the individuals, unless they wish to name themselves, of course. The whole purpose is to try to protect people. The danger is that we've gone way beyond what we originally intended, and I've very much supported the Times newspaper on its attempt to try and open up some of these courts.
But to be fair to the court is simply implementing the law Parliament has given it to implement.
Yes, that is the position at the moment, and therefore you have a position where the judges, they're specialist judges, will make decisions. Their difficulty is very much based upon listening to experts and trying to work out which side of what is a very hard case to make a decision on. And I having been in those courts, I know how difficult it is.
So, Andrew, let's come to the NHS. Why, as far as you can tell, are they trying to stop somebody having a chance? Because we've seen other cases where people have tried to have a chance, the NHS has said it won't work, and it has worked.
Absolutely. There are people alive today that, despite prognoses, have gone on to live and to live fulfilling lives. And I think one of the tragic situations in this case, and also in a number of other recent cases, is that a decision has been taken when there is actually an alternative being offered. So we've heard them in the baby cases. There was baby Alfie Evans, there's baby Charlie Gard, where the parents actually have hope to remove the children from the hospital. In the case of Alfie Evans, there was actually an air ambulance waiting at the end of the corridor.
With children, even though
Yes.
Both of those cases concern me greatly.
Yes.
It's easier to understand why the courts get involved and why
Yes.
the NHS tries to stop parents
Yes.
doing things. But in this case, she's a 19-year-old young lady. She, in the Daily Mail, as it showed, wants to have this treatment. She's able to communicate, to express her own wills.
She's a very striking young woman, certainly. And the point is this horrible disease was diagnosed very late for her. She did have some muscle loss and some difficulty, but the truth is that she did her GCSEs. Until this time last year, she was really well. She was in mainstream schooling. She caught COVID. And as a result of that, she had to go on some dialysis, had the tracheostomy put in. But all the way through, for one year since she's been in hospital, she's been told the prognosis is dire, you only have a few days to live. And she's been saying all the time, don't give me opioids. I want to be alert, just paracetamol, please, because I want to live, not die. And if I die, I want to die trying to live.
And the NHS is basically treating her like a mad person.
They're saying it's delusional.
It's delusional.
They're saying because she will not accept her prognosis, because she will not accept what the doctors say. Let's bear in mind that 1 year ago they were saying you've just got 2 or 3 days to live. They say that because she won't accept it, she is deluded.
So they've already been wrong. She was told a year ago that she had 2 or 3 days to live.
Yes.
She's outlived that by a year.
Yes.
And they still won't listen to her or allow her to have this experimental treatment in Canada.
Which the point is this, the offers are coming in from around the world. There are some that are emerging even from Europe. She says, I want to try. Even today, even to do that interview with the Daily Mail, she has been able to explain herself in her own words. She has communicated in her own words this.
And Philip, how high a threshold do the courts have to have before they deem that you haven't got mental capacity to make a decision like this for yourself?
Well, that's a very interesting point, because the general approach would be, as we have with any burden of proof, it would be a balance of probabilities. In other words, the 51% to the 49% in terms of the balancing. I think the difficulty with...
But that shouldn't be on the balance of whether the treatment will work, but on the balance of whether this is a decision that a reasonable person could make.
Well, I think it should be done on that basis. I think one of the difficulties we have is the decision-making of the judiciary is one that is very secretive in these particular types of proceedings. I think they should be opened up. I do believe that we have a clash here between the rights of the individual as against the state telling the individual what to do, and that's what worries me.
And Andrew, there is a hearing, isn't there, a further hearing on the anonymity question?
Yes, and we're very much hoping that will open up. Justice is done in the light. It's not done behind closed doors. We don't yet have a date.
You don't have a date for the hearing. Well, the sooner that happens, the better, because it's so important that we know what's going on in our courts. And, of course, as Philip said, that we allow the individual to choose for themselves. Anyway, thank you to Andrea and Philip. Don't forget to let me know what you think. mailmog@gbnews.com.